So welcome to the next in the Human-Centric Cybersecurity Partnership series of webinars. A happy festive period to you if you're joining in live in December. We're very excited to be bringing you one of our co-investigators today, Dr. Nicolas Vermeij, to talk about privacy and law. Dr. Nicolas Vermeij is a professor at the University of Montreal's Faculty of Law, specializing in the intersection of law and technology. As Associate Director of the Cyber Justice Laboratory, he focuses on the legal implications of advancements like AI and cyber justice. His expertise and dedication make him a leading voice in his field. So we're very excited to have him presenting for you today on privacy and data breaches. And with that, I'll welcome Dr. Nicolas Vermeij to the webinar.
Well, thank you, Michael, and good morning, afternoon, or evening, everyone, depending on where you are on the planet right now. It's a pleasure to be here with you to discuss, as you can see on the screen, data breach notification laws and how those laws have been drafted, how data breaches have been approached under Canadian law. So obviously, we only have roughly 40-45 minutes together, so I can't delve into too many details. And I know that this is a vast public in the sense of different interests and different skill sets in different fields. So I'm taking for granted that most of you are not particularly versed in the law and therefore will have a higher approach, if you will, to the issues. But to get started, obviously, when I'm talking about our data breach notification laws effective, I'm referring to Canadian laws in particular. I could talk about European or American data breach notification laws and the approaches that were chosen. I'm going to put those aside, seeing as, again, being a Canadian law professor, it's only normal that I concentrate on Canadian law. Now, some could argue, and listening to me for the next 40 minutes or so, you might think, well, my title probably is slightly misleading. In fact, I could probably have titled my presentation, Does Canada Actually Have Data Breach Notification Laws? And if we do, then are these laws effective? And that probably would have been a fairer approach or title, probably not as catchy though, which is why I went with the one that I did. But the reason I say that is because as you'll see in my presentation, it's actually quite misleading to talk about data breach notification laws. First of all, we'll see it's not all data, it's not all breaches. In fact, they're not actual laws dedicated to that. It's sections of existing laws that were adopted, that were modified to that end. So just to give you an outline of how I will approach Canadian, again, sections of Canadian laws that deal with data breaches, I basically identified 5 main issues that I believe make it that our laws are not quite as effective as they should be. Just to help you understand the fact that we have these laws in place, but when you're actually looking at how they are being followed and applied by the courts, you realize that that's not always the case, and it's not necessarily the case, and therefore there are underlying issues. And so those are the 5 issues that you see on the screen right now are the ones that I will approach, closing obviously with a few remarks. So let's start with issue number 1, just to stay logical in the way we're approaching the topic, and talk about the fact that, well, when we talk about data breach notification laws in Canada, in fact, we're actually talking about 3 different laws. Now, again, I put laws into quotes because it's not laws per se as much as sections of existing laws. So just to give you a historical background, if you will. Most of you who are listening to this probably have heard of the TJ Maxx or TJX privacy breach that happened in 2005. If you have not, if you are too young, if you are not born yet in 2005, I like you a little bit less, obviously, because you're making me feel old. But again, most of us have probably heard of this case. I wasn't the first data breach, important data breach case, but it was one of the first that was actually investigated by the Privacy Commissioner of Canada. And so the privacy commissioners of both Canada and on the federal level and Alberta provincially joined together to write this report. You see the title here is the report of an investigation into the security, collection, and retention of personal information, which studied how basically TJX and so all the companies that fall under their umbrella. So in Canada, that would be Winners, HomeSense, and Marshalls, and obviously TJ Maxx in the US. Well, all these companies were hacked, and basically hackers came away with 45 million payment cards, or the data associated with 45 million payment cards, as well as driver's licenses from customers, and so on and so forth. And so this was one of the first data breach cases that, again, was subject to an investigation here in Canada. Now, the reason that was the case is because, well, the Privacy Commissioner of Canada, as well as the Privacy Commissioner of Alberta, were notified by TJX and by Visa that TJX had suffered the security breach. But technically, they didn't have to. And the reason I say that is because legally at the time in 2007, when they received the notification, there was actually no data breach notification law enacted anywhere in the country. Now, there were similar laws, or there were data breach notification laws adopted already in a number of American states, and therefore it just made sense that they would notify the Privacy Commissioner of Canada, since they already had to notify individuals either directly or through a third party in the US. And so they did so in Canada as well. But legally, as such, there was no disposition of any given law that said that they had to do so. Now, that obviously changed over time. So if we look at the timeline, again, 2007, the TJX announcement, and obviously you see that it's in 2007. I mentioned that the breach happened in 2005, and that's simply because it took them almost 2 years to find out about said breach. And we'll come back to that later on, because that's one of the issues with the legislation as it stands. And so you have the breach in 2007, and in fact, it will take 2 years before we have our first data breach notification section of a law, and that is, and I just changed something. I apologize. I don't know what I did, but I believe you can still see my screen. If not, please let me know. And so basically, you have in 2009, Alberta that adopted a modification to its law and adopted a new section to the law that basically created a data breach notification obligation in that province. Now, a few years later, actually 6 years later, in 2015, the federal government decided to follow suit and adopt a modification to its privacy legislation, the Personal Information Protection and Electronic Documents Act, usually referred to as PIPEDA, and so added a section 10.1 to PIPEDA, which basically was a data breach notification obligation for corporations. And last but not least, a little over a year and a half ago now, the provincial government here in Quebec, where I am, adopted modifications to its privacy legislation, an act respecting the protection of personal information in the private sector. And by doing so, added a section 3.5, that states that now, again, here in Quebec, there is an obligation to give notice to the privacy commissioner here about the fact that there would be a breach a security breach or a data breach in this province. I say privacy commissioner, it's actually le commissaire à l'accès à l'information, so the access to information commissioner, simply because in Quebec, the person who's responsible of access to information as well as privacy is the same individual. But all three laws, although, and we'll go into more detail in a few minutes, but all three laws basically have the same basic obligation, which is that, well, individuals or businesses that suffer data breaches have to report said breaches to the commissioner of either the province or the country, depending on the law. Now, you'll notice that I put asterisks next to data and breaches because, as we'll see, it's not all types of data and it's not all types of breaches that are actually the target of these pieces of legislation. Certain types of data are actually excluded, and not all security breaches are actually considered to be breaches that need to be for which a notice needs to be sent to the commissioners. But the approach, again, for all three legal documents is the same, or legislative documents, I should say, is the same, and that is that you need to give a notice to a government body, i.e., the privacy commissioner. Now, that is actually very different from what was the tendency mostly in the US, where people or corporations actually had to directly contact individuals that were actually impacted by the breach. So basically, consumers in most cases. And that idea was put aside for a number of reasons, one of which I'm sure you're familiar with. That's a concept of notification fatigue. What we've noticed in the US, or what researchers have noticed, is that, well, when you're actually sending notices every time there's a security breach, well, individuals will receive dozens and dozens of breaches. In the text that you see on the screen right now, you can see in the middle that in 2008 in Maryland, residents received over 200 breach notifications. Well, obviously, that's not tenable. And the result of that is that basically people will not pay any attention to it. And so by making it a centralized effort and giving to the privacy commissioner of, again, the country or a province the obligation to warn individuals depending on how they evaluate the urgency of the situation, well, it makes it a little more manageable. In fact, that's the European approach as well in this particular area. But getting back to, and I'm apologies, um, getting back to the issue at hand, and that is, well, as you can see, there are three different laws, and three different laws that sometimes will all apply at the same time to the same company. And what I mean by that is if a company has business in Quebec and in Alberta and anywhere else in Canada, in fact, well, then they will be subject to every law or subject to just one of the laws, depending on who their customer base is or how much information they're gathering on individuals and where these individuals are situated. And that actually creates issues. And you might be surprised that we actually have provincial laws since we have a federal law. And the reason for that is actually relatively simple. It's Europe's fault. And what I mean by that, obviously, I'm being facetious here, but the idea being that back in the 1990s, 1995 to be exact, Europe adopted its Data Protection Directive. That's the directive that was replaced in 2018 by the GDPR, the Data Protection Regulation in Europe. And so adopted this directive, which was completed in 2002 and then in 2009 by other directives. But point being that they adopted a framework to ensure the protection of personal information on the European continent. And those directives, again, that were later replaced by the GDPR, the General Data Protection Regulation, basically said that, well, data had to be protected and there were certain obligations that companies that gather data on third parties had to follow. Now, it also said that, well, if that company that's situated in the US wanted to send data overseas, in the case that's interesting to us in Canada, well, there had to be some sort of protection for that data when it exited the frontiers of the European continent. And so there was a section in the 95 directive, and there's a similar section in the current version of the GDPR that basically said, well, if you're going to be sending information abroad, that information has to be protected by legislation that is relatively similar to European legislation. So basically, the country that is housing that particular corporation where the data is going to go has to have a law in place that's similar to the then directive, now the GDPR. Now, it's not that clear. In fact, it doesn't have to be a law. It can be other mechanisms. In the US, there's no law. They put forth other mechanisms which weren't particularly successful and had to be replaced. But again, I want to stick to Canada and focus on our situation. And so they basically said, if you want to send data to Canada, Canada has to adopt a law on privacy. Now, in 1995, and in 1995, Canada did not have a Privacy Act, and so it had to adopt one, which it did, and that's how the Personal Information Protection and Electronic Document Act, i.e. PIPEDA, came into effect. And in a 2001 decision by the European Commission, it was deemed to be considered similar enough to the 95 directive for data to be able to travel between Canada and Europe, private data in particular. And so that's what happened then. Of course, now that created an issue, and in fact, there's still constitutional issues behind all of this, because some provinces, or actually, I should say one province, Quebec in particular, already had a Privacy Act since 1993. And so now you had a law in Quebec and a federal law. And so there had to be some mechanism in place to say, well, which law will actually apply to data and in which cases, in which scenario. Um, Now, again, there was and still is a constitutional debate in Canada as to say, well, who is actually competent to legislate when it comes to privacy. But we basically, I say we, obviously the legislature decided to put that aside and come to a happy medium, if you will, and try uh, uh, to skirt the constitutional question by saying a little bit the same thing that Europe had said to Canada, which is, well, if you have a law in place that's similar to our law, you can just keep your law. So that's basically what Section 26 of the Canadian Act says, so of PIPEDA. Basically, any province that has a Privacy Act in place can keep that Privacy Act, and that's what's going to be enforceable in that particular province. And so a couple of other provinces followed suit, that being British Columbia and Alberta. They also adopted privacy legislation. There's stem from 2003. Other provinces also adopted privacy legislation, but only for certain types of data, mostly health data. But comprehensive privacy legislation is only available in these three provinces. So basically, in these provinces, the law that applies is the Provincial Act, and in every other province, PIPEDA will apply. But PIPEDA will also apply to anything that has to do with transport, with telecommunications, with banking, with interprovincial trade, and a couple of other issues. Why? Because these are all areas where the Canadian Parliament is the one that has competency to adopt legislation. And so, for example, for a bus terminal in Quebec, it's PIPEDA that's going to apply, not the Provincial Act. And same thing for banking, for example. So it makes things a little complicated. And it creates this scenario where, again, if you have a company that is situated in multiple provinces, including Alberta and Quebec, well, now you have to comply with the provincial law as well as with PIPEDA. And obviously, if you're dealing in certain areas, then you're going to be subject to PIPEDA as well. Now, what does all of that mean? Well, logically, knowing all of that and knowing that the population of Canada is obviously larger than the population of Quebec and Alberta, um, I should say of the rest of Canada, right? Population of Quebec of Alberta, all in all, is roughly 15 million people when you add those two together. And Canada being roughly 40,000 people, so basically about 40 million people. Again, apologies. So there are roughly 25 million people that are subject to PIPEDA and not to the Quebec or Alberta legislation. So you have, logically, if that's the case, then there should be a lot more breaches that have been declared in Canada than under PIPEDA than in Alberta or Quebec. And so the data that I have now, as you can see, is between 2022 and 2023. Reason I picked those dates is because I started doing my research in May of 2023, apologies, and it's in September of 2022 that the Quebec Act came into effect. So in order to be able to compare apples to apples and oranges to oranges, I needed to have to start in 2022. So again, logically, Canada should have a lot more breaches that were declared than Alberta and Quebec. But in fact, when you compare the numbers, that's absolutely not the case. Now, Alberta, as you can see, during that period had about 558 breaches that were declared. The reason it's between parentheses is because they actually don't have monthly numbers; they have annual numbers. So I basically did a pro rata of the number of breaches according to the number of months that I was doing. So it might be off by a couple of breaches, but it gives you a pretty good idea. Quebec, again, roughly 144 breaches that were declared during that period. But Canada, again, 55. Now, considering that a lot of the cases in Quebec and Alberta are probably cases that went outside that province, well, Canada should be a lot higher than Alberta and Quebec. Now, there are a couple of reasons or a couple of arguments that you could make to explain this. Alberta can be explained by the fact that, again, the law has been in place since 2009, so people actually know about that law much more than they do about the modifications to the Canadian law, which happened 6 years later. But then that wouldn't explain why Quebec had so many more breaches than Canada does, or than the federal law does. And then you might say, well, yes, but Quebec is a bigger province, but don't forget that Ontario is subject to PIPEDA. So in those 55 cases, there's Ontario, which probably, because per capita, I mean, they're bigger province than Quebec is, then they should have at least the same number, if not more, per capita data breaches than Quebec, because there are more corporations in Ontario than there are in Quebec. And so really there's no rhyme or reason to these numbers. What I tried to do is I approached all three privacy commissioners and submitted requests for information to try to find out what the companies were, which companies were, and if there were possibilities to crisscross the data to see how things worked out. Now, funnily enough, I was refused my request because they said that it could affect the privacy of certain individuals, which I find somewhat ironic, but unfortunately, that was the answer I was given. Now, I mentioned a number of declared breaches, but as for the number of cases, so court cases that actually happened, or cases that were actually filed following this by the privacy commissioners, well, you can see that on the federal level, so under PIPEDA as well as under the Alberta law, in that period, only 2 cases each, whereas in Quebec, 58 cases for the same period. So again, the logic behind that is not quite it is difficult to grasp. My hypothesis here is Alberta actually changed its way of approaching these cases, and so that might explain why the number of cases is so low, and it's much lower, in fact, than in past years. Whereas Quebec, since the law just started or was just entered into force, there's a possibility there that we're simply putting a lot of emphasis on it in order to ensure that people understand what the implications of said law are. So, first issue, confusion as to which law you're supposed to abide by. In certain cases, all three of them. In certain cases, only one of them, and that to me will affect the effectivity of effectiveness. I'm sorry, of the law. So that's the first issue I wanted to draw your attention to. The second issue is the fact that, well, we're talking about data breach notification laws, but that actually is a false statement, because we're not talking about all data. We're only talking about certain types of data. And what I mean by that is, when you're referring to data or the general concept, legally, there are two main categories of data. There's public data, and then there's confidential data. Now, confidential data or is usually referred to as private data, but as we'll see, it's absolutely not the same thing. So confidential data is something that is referred to in a number of legislative dispositions. So, for example, in the Quebec Act to establish a legal framework for information technology, Section 25 says that when you're responsible for accessing a technology-based document, so technology-based document is basically any computer file or document that contains confidential data, you must take appropriate security measures to protect its confidentiality, which makes sense, right? If it contains confidential data, you have to protect the confidentiality of said data. But it actually doesn't state anywhere in that act what confidential information or confidential data actually is. In fact, when you look through legislation in Canada, there's really no definition of what confidential data is. Now, there are certain sections of certain acts. So, for example, the Telecommunications Act in Section 39 will say, well, sometimes you can say that this particular piece of data is confidential. And so, for example, if it's a trade secret, if it's financial, commercial, or scientific data, so on and so forth, I can say, okay, this is confidential data. But otherwise, we don't have any enacted legislation that gives a clear definition of what confidential data contains, just what somebody can decide is confidential in a particular context. The closest thing we have, and this is a bill that has yet to come into force, the Critical Cyber System Protection Act, which is Bill C-26. Now, it just went through its third reading last week. So there might be some hope of it being adopted before the current government is toppled. If we follow the news currently, the chances that the current Liberal government is going to still be in power this fall when the next elections are scheduled is highly improbable, but you never know. So there is a possibility of it being adopted between now and then, although if I had to put my money on it, I would probably put my money on the fact that it won't be adopted. But no matter, the interesting thing here is that there is actually a definition of confidential information here of what it is. And as you can see on the screen, it's when you're talking about a cybersecurity system or cyber system, well, it's any information that concerns a vulnerability of that system that could be expected to result in material or financial loss for someone, or could reasonably be expected to interfere with contractual or other negotiations of a designated operator. Now, again, this is strictly linked to critical cyber systems, but at least it gives us a general generic idea. So a few years ago, I actually went through all the legislation and all the case law that dealt with confidential information to see if I could actually come out with a comprehensive definition that's went further than what I just gave you. And obviously, I could spend the next 40 minutes on that, but I will basically limit myself to saying that when you read all of the case law, all of the decisions, and all of the laws, what it comes down to when you're talking about confidential information, it basically either deals with trade secrets or with personal data. So trade secrets, I'll leave aside, and I'll concentrate on personal data. So personal data, for those of you who weren't familiar with the legal definition of it, is any type of personal information with which relates to a natural person and is directly or indirectly allowed directly or indirectly allows that person to be identified. So obviously, your name, your phone number, your email address, your social security number are considered personal information, as is the color of your hair, color of your eyes, your height, your weight, because these are all things that indirectly could identify you, especially if taken with other pieces of information. So personal data, part of confidential data. And then you see that there's a sliver in my Venn diagram of personal data that's actually outside of the confines of the circle of confidential data. And that's because, according to the law, again, there are certain elements or certain pieces of data that are personal data, but that are not considered to be confidential. And that's mostly data that has to deal with your place of business or data relating to a court case, for example, which will not be confidential because court cases are public. So there are obviously exceptions to it. So getting back to my initial question, which is, well, does Canada actually have data breach notification laws? And the true answer to that is, well, not really. What it has are personal data breach notification sections of acts, because the three laws that I mentioned, the act out of Alberta, the one out of Quebec, and PIPEDA, well, all three of those acts are actually personal data protection acts. So when you're talking about data breach notification, well, that only applies when the data is personal data. And so if it's not personal data, if they're trade secrets or any other type of confidential information, for example, the credit card information for a company card, well, that would not fall under personal data, and therefore you don't have an obligation to notify if there's a data breach concerning those types of data. Now, I'm not saying there's not a common law or a moral obligation, but those particular dispositions, those specific particular sections of the three acts that I mentioned before, do not apply to data that is not considered private data. And so already these acts are not as wide spanning as one might expect, and it only deals with private data. But even then, when you're talking about protecting private data, it's not protecting private data in all cases. It's only certain types of breaches that are actually the subject of these. So with this public, I don't have to go into too much detail. Usually I do so with when I'm talking to lawyers who are not necessarily as familiar with the DIC triad or CIA triad, depending on your language, DIC being the French acronym, or AIC, again, depending on how you want to present the letters. But the idea of basically, as we know, when you're talking about a security breach or security in general, what you're actually talking about is the confidentiality, integrity, and availability of data. Now, when you actually look at these acts, the federal one is pretty good in the sense that it says that an organization shall report to the commissioner any breach of security safeguards involving personal information. And so it does not specify which element of the triad it's actually looking at. But when you go to the Quebec Act, well, it's very clearly limited to confidentiality incidents. which means that basically if there's a breach and the breach results in the destruction of data, but the confidentiality of that data has not been affected, or the integrity of the data has been affected, but again, not its confidentiality, then technically under the current drafting of that of Section 3.5 of the Quebec Act, there's no obligation to send a notice to the Quebec commissioner. Um, Same thing in Alberta. In Alberta, we're talking about loss or unauthorized access to or disclosure of personal information. So unauthorized access to or disclosure of that clearly deals with confidentiality. Now, loss of, we could technically say, well, that has to deal with availability. But that's actually a somewhat surprising turn of phrase, because loss of data usually is not presented in that manner under Canadian legislation. But so clearly a confidentiality, possibly availability, but again, integrity is pushed aside and forgotten in this particular section of the Act. So third issue being that we're only talking or mostly talking about the confidentiality of private data. And this brings me to the fourth issue. And that is, well, okay, now we know that we're dealing with private data. We know that when there's a confidentiality breach of private data, we have to uh, give notice to one of the commissioners in place. But is it all privacy breaches or only certain privacy breaches? And the answer to that, you've already probably guessed, is, well, it doesn't apply to all privacy breaches. Now, I started looking into this following this article that was published in La Presse a few years ago. And basically, this author or this journalist, and now I now realize that the name of the journalist is not on the screenshot, and I do apologize for that. But basically, this journalist started looking into the few cases. This was written a couple of weeks after the Quebec law came into effect, and looked into the few cases where people were had actually registered that they had a privacy breach. And it was interesting to see how which breaches were being communicated, or for which a notice was being sent to the equivalent of the privacy commissioner here in Quebec. And the reason for that is, again, it's not all privacy breaches that need to be sent to the commissioner, because that would obviously be too much of a hassle for everybody implicated, and it would just create huge backlogs. And so the law states that, well, it's only when an incident presents a risk of serious injury to obviously the customers or the clients or partners, or basically individuals whose private data has been the subject of the breach. Well, it's only in if there's a risk of serious injury to these individuals that the notice has to be sent. Now, of course, the logical question that you're probably all asking yourselves right now is, well, what is a risk of serious injury? And truth be told, the answer to that is, I have no idea. Now, that's not quite true. Obviously, we have an idea of what a risk of serious injury is, but since the courts have yet to analyze that section and give an interpretation, and since there's nothing really in the Quebec Act that explains what a risk of serious injury is, well, then we have to fall back on the general concept in Quebec law, and that is, well, what does a reasonable person believe a risk of serious injury is? And when I say a reasonable person, what I actually mean is, well, if I'm in front of a judge someday, will the judge think that there was a serious risk or not? Now, I should say that the terminology is a bit different in Alberta, where it says that there exists a real risk of significant harm, but obviously the difference between significant harm or a risk of serious injury is not particularly significant. Pardon the pun. And then if you look at the federal level, well, again, more or less the same vocabulary. We're talking about the belief that the breach creates a real risk of significant harm. Now, the federal legislation actually went into a little more detail. It says, well, there are certain factors that will help you analyze whether or not you are in a situation where there is a real risk of significant harm. The first one is, well, is the information sensitive? What is the probability that the information has been or will be misused? And any other prescribed factor. Obviously, that last one, not particularly useful. So again, general idea here, but no real details for now. And that makes it quite difficult for individuals to know, well, do I need in this particular case to give notice or not? And on top of that, well, they might say, I don't, I'd rather take a risk and not actually give the notice because you have that issue of, well, establishing harm, but there are also other issues at hand. The first one is, well, is the fine that I may have if there is someone that finds out, if the commissioner finds out that I did not give notice when I was the victim of a breach, is that fine actually going to be superior to the reputational harm that I'm probably going to suffer if the information becomes public? Now, on that element, I must say in Quebec, the fines are extremely steep. The fines have been basically copied and pasted from the GDPR in Europe. And so we're talking about for an offense, first offense, a fine of 5,000 to 100,000 for a natural person, so an individual, but it can go up to $25 million for a company or even 4% of its worldwide turnover. So it is a very steep fine if it's found out that you noticed the data breach, considered it to be significant, and did not give warning. But once you've said that, well, then you have other issues at hand, which is, well, first of all, as we know, it's rare that a data breach is found on the day that it happens. IBM, in its annual report in 2024, states that for 40% of breaches, it can take up to, on average, 283 days. Now, obviously, this has to be taken with a grain of salt. This is data compiled by IBM, and I don't know what the methodology is, but I mean, IBM is a reliable source usually, so I tend to believe these numbers. And in fact, we have examples getting back to the TJX case that I mentioned at the very beginning of my presentation. Well, the TJX case took almost 2 years, and so it's not out of the ordinary to think that 283 days could be the right average. Now, why is that an issue? Well, if I now find out that 283 days or even more or longer ago, my consumers or my clients were the victims of a security breach, or I was the victim of security breach that put their data in danger, it's probably a little too late now to tell them to mitigate their damages, because obviously, if somebody were to steal their identity, it probably already happened. But then on top of that, there's obviously the issue as we all know, well, there are attempted security breaches, and then there are successful security breaches, and then there are the detected security breaches. And so, really, it's that sliver, the security breaches that were successful and discovered, that are the ones that we can actually give notice to or of. And so all of the other security breaches, well, we just don't know that they happened. Now, the second issue again is the risk of significant harm or serious injury, and again, getting back to the article that I mentioned before, he gave a few examples. Some of them were obvious. One of them was a delivery company that was delivering a box of prescriptions to a pharmacy, and it was raining when they brought the box in, and so the top of the box had started disintegrating, and you could read, if you actually look through it, the names of some individuals that were written on some of the bottles of medication. Now, I probably, in all honesty, would not have considered that to be a serious risk of harm, because only one person actually could have seen this, and that's the delivery man. And I'm pretty sure he did not take the time to jot down those names. Now, I could be wrong, but if I were the one to interpret whether or not that was a risk, a serious risk of harm, I probably would not have uh, uh, gone forward and given notice to the privacy commissioner. And last but not least, there's a big issue of a difficulty to establish liability. And what I mean by that is under Quebec law, under Section 1457 of the Civil Code of Quebec, when you're talking about suing an individual, so now I'm not talking about the penalty that you may or the fine that you may get from the privacy commissioner, but if I am the victim of, if my data was part of a security breach and I want to sue for the damages that were caused, well, the law states that three things have to be established. The first one is a fault. So fault on the part of the company that suffered the breach. So in this case, the fault would be the security breach. Now, case law demonstrates that the mere fact that you were the victim of a security breach does not mean that you were necessarily at fault. You are only at fault if your security breach is a security breach that a reasonable company put in the same situation would not have suffered. And so certain security breaches, because you already invested a lot in security, you have all the latest tools in place, but alas, there is a new virus, let's say, and your antivirus software is up to date, but there's a new virus that was developed, and your antivirus software did not detect it. Well, then you would not be considered at fault because you did what a reasonable company would do. And again, there's case law on that. So you have to establish fault, that the breach is a breach that a reasonable company put in the same situation would not have suffered. And then you have to say that you have to prove that you were the victim of injury. The classic example here is identity theft. And last but not least, you have to establish that there's a causal link between the two. And that is where it becomes extremely difficult because, as we know, numerous companies have access to our data. A lot of companies have our data, and we don't even know that they have our data. And so I have to establish that company X has suffered a security breach and that it is the one that is responsible for the identity theft that I'm the victim of, and that it's not company Y that has also been the victim of a security breach. And so how do I establish that company X is the one that's responsible, especially if, well, it didn't actually advertise or send notice that there was a breach, because in many cases they just didn't detect the breach, or they just decided to not abide by the law and make the information available. And so all that to say that when you look at everything I just mentioned, our data breach notification laws are not effective. There is much room for improvement, mostly because data breach laws are too narrowly construed. And I'll even go further and say because there's not sufficient funding of the privacy commissioners on both levels, so federal and provincial, to give them the basically the weapons needed to try to establish if breaches occurred and when they occurred and who is responsible for them. Now, I can also try to see the glass as being half full, or see a bright light at the end of the tunnel. Obviously, these laws are relatively new, specifically the Quebec one, which is again less than 2 years old. So, as case law develops, as fines are being handed to these corporations that don't abide by the law, well, maybe we'll have a better idea of which breaches should be considered as causing serious harm and which should not. And when you know that a couple of companies have paid steep fines for not coming forward, then more companies will come forward in the future. Um, and secondly, and lastly, I have some hope that Bill C-27 may change things. Now, Bill C-27, for those of you who weren't familiar with it, is basically a revamp of PIPEDA. So they're basically breaking PIPEDA into two different laws, a Privacy Act, a Electronic Documents Act, and adding a third law, which is the Artificial Intelligence and Data Act, which is the one that most people associate with Bill C-27. Now, right now, as it stands, in its current drafting, Bill C-27 for data breaches has basically just taken the exact same wording as the current version of PIPEDA. But that law is still being rewritten, still being studied. In fact, I'm pretty sure, again, it's not going to be adopted before there's a change of government. And so it will definitely change between now and then. Probably, again, will be abandoned and a new bill will be presented in the next year or so. And so maybe there will be changes there to make the law more effective. On that note, I thank you for your attention. And obviously, if there are any questions, I'll be happy to do my best to answer them, knowing that there's about 8 minutes left to the presentation, or before the um, everything is done. So thank you.
Thank you for that very interesting presentation, Professor Vermeyen. We do have some questions, which is wonderful. So what I'll do is I'll read out the question for you. I'll leave you to interpret the question and answer it as best you may. So with that, our first question is from Mr. Singh. He says, one thing that I noticed in Article 25.1 is that instead of focusing on the presence of law governing privacy obligations, focus is on ensuring a similar level of protection. If PIPEDA does not provide a comparable level of protection as GDPR, wouldn't the EU be justified in restricting cross-border transfers?
And the answer to that is yes. So again, under the previous version of the GDPR, so the 95 directive, they actually studied the Canadian PIPEDA to make sure that it complied. And there was a decision by the European Court to say, yes, it complies. Now, one of the reasons for Bill C-27 is to ensure that the current version of PIPEDA is updated so that it complies with the GDPR. Because right now, if somebody contests the compliancy of PIPEDA with the GDPR, it is possible that the court would come to a different decision and say, well, it's no longer in compliance. That's what actually happened in the US on a number of occasions. They put vehicles in place. First, it was the safe harbor principles, and those were then set aside because the court said that they did not comply with Section 25.1. And then they adopted the Privacy Shield, and the same thing happened. And now they're at the fourth iteration or third iteration of the Privacy Shield to try to ensure that data can still circulate between Europe and the US. But yes, currently we're in a critical area where the GDPR was adopted. Modifications were made, obviously, to the 95 directive. So PIPEDA needs to follow suit in order to still be at the same level. Quebec has already done that exercise, so the Quebec law is closer to the GDPR than PIPEDA is. But on a federal level, we still have that risk that eventually European courts could say PIPEDA is no longer in compliance or sufficiently compliant.
Wonderful. For the next question, Are there any monetary penalties in Canada if an organization is found in breach of its duty to report? If yes, what is the amount, and has a penalty ever been imposed?
So the answer is yes. Penalties, so current penalties are not particularly steep. Again, under Bill C-27, we're also following suit with the GDPR. So we're talking about penalties like the ones I mentioned for Quebec. So we're talking about millions of dollars or 4% of your annual gross. Have penalties been imposed for now? The way it works for privacy, and I see it's Benoit that asked the question. Hello, Benoit. The way it works for the Privacy Commissioner of Canada is that when somebody complains to the Privacy Commissioner, they basically draft a conclusion. The conclusion is the conclusion to a study that they do to see if the law was abided by or not. And basically, if they come to the conclusion that the company did not abide by the law, then they will just say, this is what you need to do from now on. So usually there's no penalty there. It's only if they refuse to abide by a conclusion, then the privacy commissioner can bring a case in front of the courts on behalf of Canadian citizens, basically. And then it will depend on the facts, and then the judge has a lot of leeway.
Wonderful. Another question about international cooperation here. What would happen if a database operating in Canada reports on a European case? Would personal data obtained in the course of legal proceedings be regarded as confidential if we consider the right to be forgotten?
So two things there. One, the right to be forgotten under Canadian law is not... So my personal claim is that it does not exist under Canadian law. And what I mean by that is the way it was drafted, it's not seen the same way as it is in Europe. So the obligation isn't as strong here. So that's one element. So basically, if a database operating in Canada reports on a European case, well, because Canadian individuals are not subject to European court orders saying, for example, that data cannot be made public, it would be difficult then for these people to be punished under European law. And we've seen situations like that here in Canada. The best example is there's this famous case here in Canada that a divorce case. Well, actually, it's a couple that was not married, that separated. They had children. He was a multi-billionaire. And basically, because they weren't married, she wasn't allowed spousal support under Canadian law. And she claimed that she still should get it. And this went all the way to the Supreme Court. Now, in the media, because they're children, we're not allowed to talk about it. Because the couple had children, we're not allowed to name them. So it became the case of Eric v. Lola. Now, everybody knows in Canada, or in the legal profession at least, who Eric and Lola are. And if you don't know who Eric or Lola are, all you have to do is go on any American newspaper, because they're not bound by Canadian orders. And so they basically just said who Eric and Lola are. So I can't say it. I'm a Quebec lawyer and therefore have to abide by the rules of Quebec courts as an officer of the court. But American journalists do not have to, and therefore that information is out there. So that's one of the issue with international law and the applicability of case law or court orders outside of the province or outside of the country.
And with that, I think we'll bring the webinar to a close. We're running up against time. So thank you very much to the audience for their time and their questions. And thank you very much to you, Professor Nicolas Vermeij.
It's a pleasure.